Hello everyone, I am Dr. Navjot Karkamal. In your last module, you learnt about some basics of Information Technology Act 2000, its objective, relevant laws and amendment, etc. But I suppose still there are many questions in your mind which need to be addressed and answer should be there. So today we will try to get answer for those questions from our legal expert. Welcome Dr. Anupama Saxena. She would answer our queries, and I hope till the end of this module you would have a clear picture about the legal options, procedure followed, shortcoming in the legal framework. So on behalf of yourself and from myself, I welcome Dr. Anupama Saxena. Welcome ma'am. I welcome you to the today's discussion on important aspect of Information Technology Act. We will be taking like some important questions which are very important for the users which are using internet and which are unknowingly becoming the victim of the cyber crimes. So, we will be taking various questions for the clarity of the students.
Ma'am, I will try my best to answer your queries.
Ma'am, the very first question to my mind that if somebody becomes victim of such computer and cyber crime, where he or she should approach?
Yes, ma'am. The very first response that comes to everybody's mind in case of any crime, be it a cyber crime, the matrimonial crime or the financial crime, is to go to the police. So, for a victim of any cyber crime also, the best way is to approach to nearest police station, or we can dial the number which our parents always wanted us to remember when we were young, that is 100. Which is the National Police Helpline number, or you can also dial 112, that is the single emergency number for any kind of distress. You can call on this number 24/7 from anywhere in India, and it is free also. These numbers are for emergency, so if there is a cyber crime like sexual exploitation or any crime for that purpose, you can always call on these numbers or go to the nearest police station. You can also dial 155-260 during 9 AM to 6 PM. It is a cybercrime reporting helpline number given on the National Cybercrime Reporting Portal, which is a national portal for cybercrimes. There is a toll-free number also for cybercrimes, that is 180-209-6789, or you can always find a contact number of your local cyber cell very easily. It is very much available on internet, and you can find even the WhatsApp number of your local authorities on internet. If you are comfortable with mobile or computer, you can always use the National Cybercrime Reporting Portal. The address is cybercrime.gov.in. Even if you are victimized online by foreign nationals or foreign company, you can file complaint on this portal. In case it is opposite, means if a foreigner is victimized by an Indian national or company, he can also file complaint on this portal. This portal is especially developed for cyber crimes, and since it is connected to your local cyber cells, they can easily transfer your complaint to the concerned authorities, and you will also receive a confirmation of submission of your complaint on this portal itself. Then you will also receive a SMS and email. You can also track and check the status of your complaint on this portal. Now, one more step which you can take is in case of cybercrime which is relating to social media, like publication of objectionable contents on Facebook, YouTube, Twitter or Instagram, etc. You should always report that to the concerned social media website so that they can take appropriate action based on their content policy.
Ma'am, the next question is, when somebody goes to a police station for complaining computer and cyber crime, what type of the documents are required to carry there?
Madam, whatever you have with you that shows that the crime is committed and which is related to your complaint should be with you. That may include any debit or credit card receipt, bank statement, envelope if you have received letter or any item through mail or courier, online money transfer receipt, copy of email, then URL of web page, then chat transcripts, suspect mobile number, screenshot, videos, images, whatever, or any kind of document which is related to your crime.
Ma'am, you told us about the cyber cells. What are these cyber cells and who is responsible for investigation in these cyber cells?
Ma'am, these cyber cells are like the specialized police stations for cyber offences. They are just like any other police station, but they are especially dealing with cyber offences and they are notified by the state to do so. Therefore, you will find cyber cells in almost all the cities or at district level working under this umbrella and assisting other police stations with technical help in the cases of cyber crimes. Because our traditional police stations cannot investigate in cyber matters without proper equipments and technical support. Some states, for example, exercising their power under section 2S of the Code of Criminal Procedure 1973 have notified their Criminal Investigation Department, that is CID, as cyber police stations. So they become a specialized police station. You can call it a cyber police station if you want. We also have a nodal cyber cells in every state and union territories, total 37 in number, and each cell have a nodal cyber cell officer and a grievance officer. They are the police officers of senior rank, from Deputy Superintendent to DGP, that is Director General of Police. So either you go to a cyber cell directly in case of cyber crime or any other police station. Ultimately, if a case is related to cyber crime, they will send you or your matter to their specialized cyber offences police station. Now, as far as the investigation is concerned, after the amendment of 2008, the power to investigate the offences under the IT Act as per section 78 is with the police officer not below the rank of inspector.
Ma'am, next question is how IT Act is helpful in the investigation?
Ma'am, the Information Technology Act is very helpful in the sense that it is the primary law dealing with cyber crimes in India, though not exhaustive, as we need always to look into the provisions of Indian Penal Code, Arms Act, NDPS Act, and even some intellectual property right offences to cover a whole range of cyber offences. Similarly, it helps the electronic transaction and e-governance, but again we have to take into consideration various commercial and property laws along with that. So, the Act is very significant as it provides for various important definitions relating to information technology, enumerates a number of cyber wrongs, it includes both civil and criminal wrongs, and establishes authorities, tribunals, and also provides punishments. But as far as investigation and evidence part is concerned, it does not say much about it, except for who will be the investigation officer, and if someone fails to provide the evidence, he shall be liable to punishment. For procedure, we have to follow the provisions of Criminal Procedure Code, and for evidence, we need to follow the procedure given in Indian Evidence Act. But this is not a drawback of this act, because we can always add some special procedure, and as we know that where there is a special procedure given in Information Technology Act, that is going to override the Criminal Procedure Code.
The next question is, what procedure is followed by the IU?
Ma'am, after the filing of complaint, and if the IO finds that an offence is committed under the IT Act, an FIR is filed as per the provisions of CRPC. Then investigation starts with the search and seizure of digital evidence. Digital evidence means an intangible form of data available in virtual world. The investigation officer has to look for a place where there is suspicion that computer or networks of different computers are likely to be found. The investigation officer needs to survey the equipment and needs to take precautionary steps before seizure of the system or the network, so that no important data is lost. The next step is labeling and picturing the entire network site before the seizure begins. Each and every part of the network system needs to be labeled correctly so that everything can be reassembled accurately. Once everything is labeled and powered down taking due care, the confiscation can be started. And a proper procedure should be taken while seizure of the system along with the documents related to the system or the working of the system should be seized, as well as the manuals seized might be referred by the examiners at the forensic lab, then all this evidence along with the opinion of the expert is submitted in the court.
Ma'am, please tell whether every cybercrime case is being referred to the cyber lab?
No ma'am, forensic lab and forensic expert is not needed in every case, because not every crime investigation demands that. And so far IO is concerned, he also is trained for such investigation. I mean, he very well knows that in case a computer system is down, he should not try to turn it back, or as it might lead to eradication of the entire data in the system. Likewise, if a system is up and running, then it shouldn't be turned off before consulting and checking. This is just a small precaution. IO is more experienced and trained in such investigation nowadays, as continuous training and workshops are being organized looking into the increasing number of cyber wrongs. But yes, the help of computer forensic expert may be required in a lot of operations where IO is not trained enough, they lack tools or they lack staff to efficiently conduct investigation with the volume or complexity indulged in many of the cyber cases. Especially in cases of imaging and hashing, where integrity and verification of primary evidence is very important, the role of forensic expert and his opinion is very much necessary. We can say that advice of technical expert should be relied on and availed wherever necessary.
Ma'am, please tell whether CBI is also involved in the investigation of the cybercrime at national level?
Ma'am, so far cybercrime is concerned, it has no boundaries. So, yes, Central Bureau of Investigation, that is CBI, which is a primary investigating police agency in India, also has to deal with cybercrimes in their jurisdiction, for which they have their own divisions. It is also the nodal police agency in India which coordinates investigation on behalf of Interpol member countries. So, in case of cyber crimes committed outside India or in case of international cyber crimes, the role of CBI becomes very important.
Ma'am, what are the other regulatory authorities under the IT Act?
Ma'am, under the IT Act, there is a regulatory authority, that is certifying authority, which means a person who has been granted license to issue an electronic signature certificate. Certifying authority regulates the electronic transactions. Then there is a controller appointed by the central government, which means the controller of certifying authorities appointed under this act. The controller acts as repository to all the digital signature certificates under the IT Act, make use of secure hardware, software and also procedure. He observes the standards that central government prescribes to ensure the secrecy and also the security of the digital signature. So, for cyber security, these authorities are important.
Ma'am, what is section 65A and 65B in Indian Evidence and how it is important for the evidence?
Ma'am, section 65A and 65B were added in the Indian Evidence Act by the Information Technology Act 2000. Section 65A lays down that the contents of electronic records may be proved with the provisions laid down in section 65B. Now, section 65B, which is about admissibility of electronic records, states that any information contained in electronic records which is printed on a paper, stored, recorded or copied in an optical or magnetic media produced by a computer shall also be deemed to be a document. If the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceeding without any further proof or production of the original. The conditions under section 65B are: first, information was produced during the regular course of activities by the person having a lawful control over the computer's use. Information has been regularly fed into the computer in the ordinary course of said activities. Throughout the material part of said period, the computer was actually operating properly or the improper operation as not such as to affect the electronic record or the accuracy of this content. Information contained in the electronic records reproduces or is derived from such information fed into the computer in the ordinary course of these activities. So, you can say that the primary purpose is to sanctify or to approve the proof by secondary evidence. This facility to prove by secondary evidence would apply to any computer output. Such output be deemed to be as document. A computer output is deemed document for the purpose of proof, where the information was processed or fed into the computer on interlinked computers or one computer after the other in succession. All the computers used shall be treated as a single computer. Section 65B also lays down that for the purpose of evidence, a certificate identifying the electronic records containing the statement and describing the manner in which it was produced by the computer and satisfying the conditions mentioned in the section and signed by an officer in charge of the operation or management of the related activities shall be the evidence for any matter stated in the certificate. It shall be sufficient for the matter to be stated in the best of the knowledge and belief of the person stating it. So, the admissibility of the secondary evidence, secondary electronic evidence actually has to be adjudged within the parameters of section 65B of the Indian Evidence Act. The proposition is very clear and explicit that it is the secondary evidence is, if the secondary evidence is without a certificate under 65B of Evidence Act, it is not admissible. And any opinion of the forensic expert and the deposition of the witness in the court of law cannot be looked into by the court. Thus, in case of a CD, VCD, chip, etc., they shall be accompanied by the certificate in terms of section 65B obtained at the time of taking the document, without which the secondary evidence pertaining to that electronic record is inadmissible.
Ma'am, what are the cognizable and non-cognizable crimes, and what do you mean by the bailable and non-bailable crimes in IT Act?
Ma'am, if we read section 77B of IT Act, it says that offence with 3 years imprisonment to be bailable. It provides that notwithstanding anything contained in the Code of Criminal Procedure 1973, the offences punishable with imprisonment of 3 years and above shall be cognizable, and the offences punishable with imprisonment of 3 years shall be bailable. Now, bailable offences, as we know, are regarded as less grave and less serious, in which bail is claimed as a matter of right. Non-bailable offences, on the other hand, are grave and serious offences, and in this in these kinds of cases, the bail is not a right of a person, but it is the matter of the discretion of the court. In cognizable offence, a police officer may arrest without a warrant, whereas in a non-cognizable case, police officer has no such authority to arrest any person without warrant. So, this is all about cognizable and non-cognizable offences and bailable and non-bailable.
Ma'am, please tell that how the punishment is considered in such type of the cybercrime cases, whether it goes like it is compounded or it goes side by side.
Ma'am, the Information Technology Act provides for the compounding of offences under section 77A, which says that a court of competent jurisdiction may compound offences other than offences for which the punishment is for life or imprisonment for a term exceeding 3 years has been provided under this act, provided that the court shall not compound such offences where the accused is, by reason of his previous conviction, liable to either enhanced punishment or to punishment of a different kind. Provided further that the court shall not compound any offence where such offence affects the social economic condition of the country or has been committed against a child below the age of 18 years or a woman. It also provides that the person accused of an offence under this act may file an application for compounding in the court in which the offence is pending for trial. And the provision of section 265B and 265C of Code of Criminal Procedure 1973 shall apply in that case.
Ma'am, as per the statistics, not even the 5% cases they are reaching up to the level of FIR. Why is it so?
Ma'am, there are several reasons for it. Awareness is the first reason. Most of the people are not even aware that they are being victim of cybercrime. For example, if someone is withdrawing money monthly, just ₹1 from your account, you may not be even noticing it. But actually what he is doing is that he is withdrawing ₹1 from 10 lakh people. So it is a huge sum for him. So it happens with most of us, we don't even notice that ₹1 is regularly deducting from our account. So in that case, we should be aware of that. The second is people sometimes don't find it comfortable to go to the police station for less serious kind of cybercrime. What they usually do is they just throw away their SIM card or they just change their IDs. Another reason is that the digital evidence is not that easy to collect. You just cannot keep it like all other physical evidences. So collection and analysis of digital evidence requires more time and expertise. Jurisdictional issues make the investigation more time consuming and difficult. So this is one more reason. Since no special procedure is provided in the Information Technology Act, the investigation is still done with the same old procedure prescribed in CRPC, which is very lengthy. So this is one more reason. Lastly, the number of cases are increasing very rapidly and the system is not changing with its pace.
Ma'am, why it is very hard to investigate cross-border cyber crimes? Do we have any measures like any type of the treaty which help in the investigations?
Yes, ma'am, we do have such kind of process. The first process is the Mutual Legal Assistance Treaties, that is called MLET, among countries for cooperation in criminal matters. Under the MLET, a country can request for obtaining evidence for criminal investigations and prosecutions. The evidence includes witness statement or the service of documents, among others. As per allocation of business rules of Government of India, Ministry of Home Affairs is the nodal ministry and the central authority for seeking and providing mutual legal assistance in criminal law matters. The Ministry of Home Affairs, that is MHA, receives all such requests, examines them and take appropriate action. So Ministry of Home Affairs takes care of it. So far we have MLT with almost 37 countries, including USA, Russia, UK. Ma'am, second process is letter rogatory, which is a formal communication in writing sent by the court in which action is pending to a foreign court or judge, requesting the testimony of a witness residing within the jurisdiction of that foreign court, may be formally taken thereon under the direction and transmitted to the issuing court, making such request for in pending and legal contest or action. It is governed by the provisions of CRPC, which are section 166, which provides for a letter of request to competent authority for investigation in a country or place outside India. Section 166B of CRPC talks about letter of request from a country or place outside India to a court or an authority for investigation in India.
Ma'am, please tell whether any bill is pending regarding the Information Technology Act?
Ma'am, apart from the fact that Information Technology Act required a lot of amendments, the most important bill right now pending is the Personal Data Protection Bill 2019.
And finally, ma'am, please tell what are the grey areas in the Information Technology Act which need to be addressed?
Yes, ma'am, there are some shortcomings in Information Technology Act 2000. The first is that it does not deal for proper intellectual property protection for electronic information and data. As you can see, copyright and trade name and other issues are very challenging to deal with. It does not cover various evolving forms and manifestation of cybercrimes. Then there is no substantial provision for data protection in the Act. However, as I told you, the bill is pending, but it was not there in Information Technology Act. The Information Technology Act talks about the unauthorized access, but it does not talk about maintaining the integrity of customer transaction. That is another reason. The Act does not lay down any duty upon banks to protect the details of customers and clients. Privacy protection is another issue, then cyber war is one more issue. The quantum of punishment, it is always debated that it is very less in reference to the nature of the and the seriousness of the crime. It is also said that the IT Act is stuck in the stone age of cyberspace because it has not amended since 2008. And the technology has moved so fast that it is being very difficult to keep up apace with it. Ma'am, one more shortcoming is that the investigation officer is not below the rank of inspector in the Information Technology Act, whereas it is sub-inspector in CRPC. In light of lack of staff at the rank of inspector and the increasing number of cyber cases, the states are always demanding for the amendments, but so far no such amendment is done. I think all such shortcomings can be sorted out if the IT Act is amended from time to time.
Thanks, ma'am, for being a part of such an important discussion regarding the Information Technology Act. You really enlightened us with the important aspect, how the investigation goes and how the CRPC, IT Act, they are working hand to hand. So, thank you very much. Thanks for being the part of this discussion.
Ma'am, the pleasure is mine. I really enjoyed this session. Thank you very much for inviting me. Please do invite me for further discussion. Yeah. Thank you very much. Thank you.
If you have any other inquiry regarding the IT Act, you can always drop your query. Thank you once again. Hope you are truly benefited by this interactive session and thoroughly enjoyed it as I did by putting it for you. So stay safe. Goodbye.